Well, welcome everyone. Thank you very much for joining me on this lovely Wednesday. My name is Lior Samfiru. I'm the employment lawyer. And if you're watching me now, it means you're interested to know about employment law. You're interested to learn about your workplace rights. So welcome and thank you for joining me. I'm one of the founding partners of Samfiru Tumarkin LLP. They call me the employment lawyer. It's kind of a uncreative name, but it's because that's what I do. I'm an employment lawyer. I answer questions, and I log on here every week to be a resource for you, to help you understand your rights, to answer your questions, to make sure that you feel better about what you can do if you're facing a workplace problem. So this is a live session. If you're watching me right now, you can ask a question. You're live as well. You can type in that question, I'll see it, and you can walk away. Maybe you have a vaccine related question. Maybe it's a temporary layoff situation. Maybe you lost your job. Maybe someone is mistreating you at work. Maybe your job has changed, your hours have changed, etc. Whatever the issue, whatever the problem, I promise you there are solutions. There's things you need to know, and there are things that you can do. And that's why I'm here to tell you about those things. So take advantage of that. Ask your question. And of course, when you ask your question, you'll be helping others that are watching this who may be facing the exact same situation that you are. So what a great opportunity. Now, of course, you also can connect with me, and you should connect with me off air, off social media. If you want to have a private chat, a private email exchange with me and my team, easy to do. All you have to do is go to employmentlawyer.ca. You see that address below me, employmentlawyer.ca. First of all, when you go there, you can read a lot about employment law, about workplace rights. But you get my email address, phone numbers, everything you need to know, forms if you want to fill in. There's so many ways to connect so we can have that private discussion. I can answer your questions right now on social media, but I can't actually do anything for you. I can't get involved on your behalf. For me to get involved, to help you, just connect with me through employmentlawyer.ca. Well, right now, though, we are, of course, live. I'm going to start answering questions right now, but please don't wait till the end of the session. Okay, a lot of people ask questions right at the end, and I don't get to them. So ask your question right now. Again, my name is Lior Samfiru, one of the founding partners of Samfiru Tumarkin LLP. We operate across Ontario, BC, and Alberta, and I'm here to answer your questions about employment law live. So first question of the day, welcome, goes to Rocket on YouTube. Why do some employers try to enforce non-competes when they know the courts won't? It's almost as if they want to make an example out of you. Well, that's exactly what it is, Rocket. They want to make an example because they have 100 other employees there, and they want those employees to know what will happen if they leave. Okay, they want to use that as a deterrent. So you're right. In most cases, non-competes are not enforceable, but that's not going to stop a company from trying to enforce it. And if they're going to try to enforce it against you, yeah, you will win, okay? But that fight is not going to be pretty, it's not going to be cheap, and it's going to be long. So you can't just ignore a non-compete, because if you ignore it, you may get into a legal dispute with your employer. And for some people, that's simply not going to be something that you want to do. So if you have a non-compete and you're just going to ignore it, honestly, talk to your company. Give them the heads up. Just so you know, company, I'm going to work over there, but I'm not going to go after your customers. I'm not going to reveal your confidential information. I'm going to maintain the respect there. A lot of companies, when they hear that, they'll back off and they think it's fine. On the other hand, if they don't hear from you, all of a sudden they know that you work for a competitor across the street, they're going to think the worst, and they may try to enforce it. They will lose, as I said. They will lose. But again, that's not a battle that everyone wants to get into. So Rocket, hopefully that helps answer your question and helps you understand the situation. If you have a follow-up question, please ask it right now. I'm happy to answer. Well, you guys see how easy it is. Just like with Rocket, you can ask your question and you can get the answers that you need if you are facing a workplace problem. So please be like Rocket. Ask your questions. Those joining us, my name is Lior Samfiru, the employment lawyer. Next question from Facebook comes from Samantha. How do you respond to a manager who is verbally abusive and creating a toxic environment? So first of all, it is absolutely appropriate to say that's not acceptable, to say that, no, you can't talk to me like that. Now, what I want you to do, if you're going to respond, do it in writing, okay? So if your manager is abusive and treats you badly, when you go back to your office, write an email, because I want that written record saying, today during the meeting you were abusive, you yelled at me, you used inappropriate language, whatever it is. That's not acceptable, and I expect you to treat me with respect. Okay? Do that. Create that record. If you need to, you can always then forward that to HR, and you show that record, show that you've done something. It's not your word against someone else. There's a record. So if, of course, it's consistent, you should speak to someone at the company, HR, the owner, whoever the right person is in your organization. If you've done that and nothing has changed, that's when you talk to me. Okay, that's when I can get involved and get this matter resolved, even get you out of there if needed. But creating that written record, responding in writing, what a great idea. If I need to get involved, you've made my life as your lawyer that much easier if you have something in writing, including your response. So Samantha, thank you for that question. Very important one. I know a lot of people are dealing with that as well. Those joining us again, my name is Lior Samfiru. I'm one of the founding partners of Samfiru Tumarkin LLP. I'm an employment lawyer, and I am here answering your questions live right now. So ask your questions. See how easy it is. Next question from Facebook comes from Melissa. If multiple schedule changes have forced you to repeatedly lose childcare and you now have no childcare when they change your schedule again, what can you do? That's a great question. Your employer has a legal obligation to provide accommodation if you don't have childcare, if you need to care for your child because there's no one else to do that. We call that accommodation based on family status, and that's part of our human rights laws. So what you tell your employer is this: I don't have childcare, okay? It's going to take me a bunch of time to find it. So either you leave me be and you work with me until I find childcare, or we find other arrangements. Maybe you let me come in later or come in earlier to find my childcare. What your employer can't do is say, too bad, that's your problem. If they do that, that's a human rights violation. That's illegal. There's been many cases, even high-profile cases, where employers were punished quite badly for not providing that accommodation. Okay. Now, when you approach your employer about that accommodation, as I said before, in writing. Okay, Melissa, you want there to be something in writing when you've told your employer, I need your help. I need you to accommodate me. I don't have childcare. Because you don't want your employer to later say, oh, you never told me, I didn't know. All right. But they have to accommodate. If they don't, despite what I just said, you call me, you connect with me, and Melissa and everyone else to connect with me if you need to, off social media. Easy. You just go to employmentlawyer.ca. Again, employmentlawyer.ca. You'll see the phone number there, the email address there. Everything is there. So don't be bashful and use it. Melissa, hopefully that answers your question. Let me know if it doesn't or if you have a follow-up question. You see how easy it is? Melissa, Samantha, Rocket, all of them are asking questions. You can do that as well. Ask your question. Now, in between your question and as we wait for the next one, I wanted to kind of give you a list of things that your employer may not want you to know, but I'm going to tell you. So the first thing that your employer may not want you to know, but you're going to know because I'm going to tell you, is that you can't be temporarily laid off. Your employer, for non-union employees, does not have a right to put you on a temporary layoff. If your employer does put you on a temporary layoff, you can obviously choose to accept it. That's your right. But you can also choose to treat that as a termination of your employment. Call that a constructive dismissal. And that means you can require your employer to pay you severance. You can absolutely do that. So there's no automatic right to a temporary layoff. So if you've been, whether it's because of COVID-19, whether it's for any other reason, maybe even the business is not doing well, if you are put on a temporary layoff, you don't have to just sit at home and wait and hope that they call you back. You can do that. But you can also say, no, that's a termination. Now I have to get my severance. If that's what you want to do, if you're not interested in sitting at home and waiting, you want your severance, let's connect with me as soon as possible. Employmentlawyer.ca is the way to do that. So your employer is not going to want you to know that. Your employer is going to tell you, yeah, of course I can lay you off temporarily. Not at all. You've just found out what the truth really is. All right, next question today comes from Trevor. Can an employer ask about your vac status when interviewing for a job? Well, It's a tough question to answer because strictly speaking, probably not, but practically speaking, yes, because you can't stop that and you're not going to be able to do much about it. So for all intents and purposes, yes, your employer can ask you about it. And if you don't get hired because of it, that could in theory be a human rights violation, but very difficult to prove. So right now, as the law stands, you're not going to be able to prevent an employer from considering your vaccination status when they hire you. I know it's not what a lot of people want to hear, but that's the not necessarily the law. It's the practical reality. Okay. So Melissa has a follow-up question about accommodation. What is the legal term to quote the accommodation? It's accommodation based on family status. Okay, so they have to accommodate you based on family status, but you don't have to quote that. All you have to say to your employer is, I have childcare needs and I need you to accommodate me. Those are the words you need. You don't need to say family status. That's not going to change anything, but you can do that. But in writing, I have family or childcare needs. I don't have childcare. I'm my child's childcare provider. I need you to accommodate me. That's all you need to do. All right, next question today comes from Cuz0176 on YouTube. I've recently been diagnosed with a chronic illness and I work 2 full-time jobs. Can I go on short-term disability from both employers? Well, if your doctor says you can't work, that you can't work. All you need is your doctor's note, and then you can go off work. Now, if you have disability coverage through both of them, then yes, you can apply for short-term disability if you have that coverage. But it all starts with that doctor's note. Okay, if you have a doctor's note, you can be off work. Now, a doctor, for example, may also say that physically you're able to do this job, but you can't do this other job. Maybe they're different. So it's okay to work with one job and not the other if that's what your doctor is telling you should do. But it all starts with your doctor. And if you have your doctor's support, pretty much there's nothing that you can't do. Okay, so hopefully that helps. If you have any follow-up question, please ask as well. But right now, I'm still live. You're live. My name is Lior Samfiru, the employment lawyer. And as I said, in between your questions, which I want, it's my priority, but in between those questions, I'm listing a few things that your employer is not going to want you to know. But too bad, I'm going to tell you. The next thing on that list is that the terms of your employment can't be changed in a significant way. Oftentimes, an employer is going to say, well, I'm the boss, I'm the owner. I can do what I want. I can change the terms of employment. I can change your job, change your hours, even change your pay. No, your employer does not have a right to change the terms of employment. Just like you can't come in and decide, well, tomorrow I'm getting paid 30% more. Thank you. By the same token, your employer can't say to you, I've decided I'm paying you 30% less. An employer does not have a right to make significant changes. That means they can change your shifts significantly. They can change your hours, give you weekends when you don't have weekends, reduce your pay. They can't demote you. If any of those things happen, you may have the right to treat that as a constructive dismissal. Okay? By changing the terms of my employment, Mr. Employer, you've terminated my employment. Now you have to pay me severance. It's not something an employer is allowed to do. Now, I said significant. That means that an employer does have the ability to make some changes. So yeah, they could get away with a, say, 5% pay cut. You're not going to be happy, of course. Who would? But they can get away with it. If they change your hours from 9 to 5 and to 4:30, to 8:30 to 4:30 instead. Well, again, not necessarily something you're going to be happy about. But yeah, your employer can do that. But if you're working mornings, they can't put you on evenings. If you are making $25 an hour, they can't reduce you to 15. If you understand what I mean, significant changes, that term constructive dismissal has to come to mind. Again, not something your employer may want you to know, but hey, now you do. I've just told you. Those joining us, hey, welcome. Thank you very much for being here with me. My name is Lior Samfiru. I'm the employment lawyer, and I'm here answering your questions live. So ask them, type them in. You have some time still left. I'll see them, I'll read them, I'll answer them. That's how easy it is. And just like that, next question comes to us from Ariel on YouTube. My employer sent the company handbook that we need to sign. I read the handbook, but look for me as a red flag, like company rules in favor of the employer. How's my right if I force it? I think you mean, what do you do if you don't agree with it? Well, first of all, we need to understand whether you should really be concerned, okay? Because it's possible that things are very bad in it, or it's possible that it's not. So I need to see it, okay? You need to send that to me. Let me see it, and let me tell you whether you should really be worried about it. If it's something that's unfair and unreasonable, then you should absolutely not sign, okay? You can't be penalized in that situation, but let's decide if it makes sense or not. Because if it's absolutely fine, then it's okay. So I can't comment on it without actually seeing it, Ariel. So you need to send me a copy. To get my contact information, email address, phone number, fax number, all that, easy, employmentlawyer.ca. Again, employmentlawyer.ca. You see that right there. So contact me and I'll take a look. Okay, next question on Facebook from Virginia. Is there such a thing as day worker status? An employer put my husband on this. I was told it just means husband was put on call. Well, any person, I mean, you can call it whatever you want. An employer can give it names. They can call it A-level employee, B-level employee, day worker. The question is whether or not they're complying with the law. If he's on call, then there's certain laws and rights in terms of being on call. But that name, day worker, that's not a legal term. That's simply what the employer is choosing to call someone that's on call. So I wouldn't worry about the title. You can call it whatever you want. Again, that's not a legal term, just a name that your employer is using, or that your husband's employer is using. Hopefully, Virginia, that makes sense. Next question on Facebook, or on YouTube, I should say, from Laura. My son was fired while on probation and was told it was due to a coworker's complaint. Is he owed anything? Well, that's a great question, because just because you're on probation doesn't mean you don't get severance. The only way you don't get severance is if you sign an employment agreement that says the first 3 months you're on probation, and if it says that during that 3 months, if you're let go, you don't get anything. So the only time you're really on probation, the only time you can be let go without any compensation, is if you sign an employment agreement that says 3 months and we don't have to pay you severance in the 3 months. If that's what you sign, fine. Otherwise, even if you work for a month, 2, 3, yeah, you are owed severance. Now, in terms of the complaint, I'd have to know what the complaints were, how serious, how credible, did it actually happen? Did the employer investigate? But the key to remember is just because someone is a short service employee doesn't mean they're on probation automatically. The law doesn't create probation. There's no such thing as probation that the law creates. You're only on probation by way of an employment agreement if you signed one that says that. And in many cases, even someone that's worked for 2 or 3 months, they could be owed severance that could be several months. You could have worked for 2 months and get 4 months severance. Absolutely happens all the time. So don't assume just because someone is a short service employee that you don't get severance. You can actually get disproportionately more severance than the long service employee, okay? So very important to keep that in mind. Thank you for that question. Again, ask yours. We're going to continue answering questions. Next question right now on YouTube from Steph. When I return to my job, my job will still be eliminated. Does doing temporary assignments in Europe affect my severance? Okay, well, I'm not sure. Return from where? Are you on vacation? Are you sick? Are you on a layoff? So I'm not sure what you mean by that. What province you work in? I don't know what you mean about assignments in Europe. So there's a lot more information, Steph, that I need to understand here to be able to answer your question. Next question from Melissa on Facebook. Can an employer do a forced stay if I work 3 to 11 and they tell you cannot go home and must stay until 7 a.m.? No, of course not. Absolutely not. Not even close. First of all, anytime your employer tells you have to be somewhere, they have to pay you. And if your shift is 3 to 11, unless they're going to pay you overtime to stay longer, they can't. You can't stay. There's no such a thing. That's completely illegal. Okay. Hopefully that makes sense, Melissa. Any problems, call me. Again, go to employmentlawyer.ca to get that contact information. All right. Following up, great questions. On YouTube, Rocket asks, can non-competes and non-solicitation be unenforceable if it's not written correctly or it doesn't talk about what you're limited to in terms of geographic locations. There's many reasons why non-competes are not enforceable. We don't even have to list them. In fact, some can be written perfectly. In fact, most can be written perfectly, and they're still not enforceable because our courts have said we don't like terms that limit people's ability to earn a living. So even if it's written perfectly and it's limited, it may still be unenforceable. That's not the real question. The real question is not whether it's enforceable or not, because the answer is almost it's not enforceable. The real question is whether your employer is going to try to enforce it. And as I said before, that means you're in for a legal battle. So that's the real question here, Rocket. All right, Helen on YouTube asks, I did not sign a release. My employer suspended my salary continuance without record of employment. I have another 3-month salary after termination without cause. Is it good for me to apply for EI now? Yeah, you have to apply to EI now. Absolutely. As soon as you lose your job, you should apply to EI. Full stop. Always, whether you get severance or not. But I'm not sure exactly what your employer is doing there. And it's not clear to me. You need to call us as soon as possible because you could be owed many months' pay. You say 3 months, you could be owed 20 months. So, Helen, before you even apply for EI, before you do anything, definitely before you sign anything, you got to call me, okay? Call my office. Just go to employmentlawyer.ca. You also see the number there below me, but if easiest to remember, go to employmentlawyer.ca. Phone numbers there, emails there, forms are there. It's all there. Don't do anything without speaking to me, okay? Employmentlawyer.ca, Helen. EducateTube has the next question. My wife has been working for the healthcare institution for 20 years and has been vaccinated twice with 2 infections. She had side effects from the vaccine. Doctors dismissed it and won't write her an exemption from the booster shot. She is now going to get fired if she does not get the 3rd shot. What should she do? So here's the thing. First of all, if she's part of a union, only the union can help. But there's nothing I can do, you can do. It has to be the union. If she's not part of a union, she has to make a decision. Would she rather get the booster and keep her job or lose her job and get severance? You can't physically stop her employer from letting her go. You can't call in the police and have them arrested if they let her go. So she will lose her job if that's what they're telling her. But she's going to be owed severance. You say she's been there for 20 years. She could be owed 18, 20, even 24 months of severance. Okay, the fact that she's choosing not to get the 3rd vaccine does not deprive her of severance. She's going to be owed severance. Now, this, of course, all assumes she is not part of a union. If she's part of a union, forget about everything I said. Only the union can help her. She may or may not have rights. She has to talk to the union. If she is not part of a union, she needs to call me. Okay, not next month, not next week. She needs to call me now. Okay, employmentlawyer.ca for that contact information. But yeah, she absolutely has rights, but you can't stop your employer from letting you go. It's just a matter of the compensation that they owe you. All right, great questions today. My God, love those questions. Next question from YouTube comes from Joseph. Has there been any court precedent about unvaccinated person terminated without severance? No, they have not been. But the reason they haven't been is because these cases have resolved. They've settled. We've negotiated settlements with the company. They've paid compensation. At some point, there could be a case that goes to court, but there may never be, okay, because they resolve, they settle out of court. But there have not been no court decisions anywhere in Canada surrounding this issue. Okay, Steph on YouTube. I'm employed with a federally regulated company for 30 years. My job has been eliminated. I have been asked another province for a few months to help. Will that affect my severance? Yes, it will affect your severance. But we need to understand how much, and we need to understand whether or not you even have the obligation to take that other position. In some situations, if you don't take the other position, it could impact your severance as well. In other cases, it may be better not to take that other position, depending on the circumstances. So we need to speak, especially if you've been there for 30 years. Your severance, you're going to get the maximum, likely, right, which is 24 months. So this is not something that you can do based on something that I said on social media. You need to call my office. There's too much at stake here, too important, Steph. So connect with me through employmentlawyer.ca. You see that right there. Phone number, email, all there. Last few minutes, guys, ask your questions. My name is Lior Samfiru, the employment lawyer. And that's great. Let's see. Educate yourself, or Educate Tube says, what if she only gets 3 months severance? Well, it doesn't matter what she gets. It matters what she's owed. Okay. And if she's been there for 20 years, she's owed a lot more than 3 months, right? So forget about what they offer her, what they give her. It's about what she is owed. If she is owed more, we'll get her more. But she needs to contact my office. We're representing hundreds of people across Canada in exactly this situation when they've been let go because of their vaccine status. Every day we're negotiating settlements. So Educate Tube, she needs to call me, okay? Like not next month, as I said, now. Let's see. Let me give you some other information. If you want to find out more about your rights, especially if you want to calculate your severance. So Educate Tube, you asked about severance. Here's how you can find out, and your wife can find out how much severance you are owed now. You don't even have to call me for that. To find out how much severance you're owed, we have our severance calculator. You can find it by going to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. When you go there, you'll see our severance calculator. You can just click on that and use it. It's free, completely free. No credit cards, nothing. It's anonymous. You don't have to put in your name. You don't have to put in the company's name. You don't have to put in your address, nothing. It's just there for your information. Close to 2 million people have used it across Canada already. So check it out for yourself, pocketemploymentlawyer.ca. You'll be shocked often by how much severance you are legally owed, okay? It's not a week per year. It's not 2 weeks per year. For many people, it can be a lot more than that. And I do mean a lot more than that. So again, go to pocketemploymentlawyer.ca, use our severance calculator tool. One of the great things you can do there. Rocket asks, next question, in terms of non-solicitation, can they still be enforceable even if it's written poorly? So with non-solicitation, they tend to be enforceable. It would have to be written very poorly and be completely unreasonable. You know, it would have to say you can't solicit a client that we ever did business with in 20 years anywhere in Canada. You know, it have to be very, very broad. Usually they're not that bad. So with non-solicitation, non-solicitation simply says that if you leave us or if we let you go, you can't go after our clients or customers. In most cases, that is enforceable, okay, in the vast majority of cases. So if you're going to breach it, yeah, you're going to be involved in legal action potentially. So you have to keep that in mind. But otherwise, yeah, it's important to understand. And if you are accepting a job, by the way, if you want to have your employment contract reviewed, you have to. There are terms a lot more important than whether your salary is $65,000 or $67,000. A lot more important than whether you get 3 or 4 weeks vacation. Okay, so very important to have it reviewed. If you want to do that, again, reach out to me, my team. Employmentlawyer.ca is the way to do that. We review contracts, and you can negotiate those contracts. It's easy for me to say, oh, this is not a good contract, goodbye. That makes no sense. But we can talk about how we negotiate. It's not complicated. You can actually negotiate those employment agreements. All right, but right now, still have a couple minutes. Ask your question. Last chance, guys, okay? Don't wait. Next question comes from Carrie on YouTube. Can my employer fire me while I am on a medical or disability leave? They've started asking more about my return to work timeframe, but I'm not there yet. Well, your employer certainly cannot fire you because you're on a disability leave. Okay, no, that's a human rights violation. Now, if they shut down the department and you're one of the people in the department and they let everyone go, yeah, they can let you go even though you're on a leave because it has nothing to do with the leave. But you cannot be let go because you're sick or because you're off on a disability leave. That's illegal. That's a human rights violation. Now, in terms of returning back to work, you don't have to have a date. You can be off a year, 2 years, as long as you're working and getting better. All you need is a doctor's note, okay? A doctor's note saying that you're off work, and you can update them every once in a while. If they keep asking you questions, just tell them, when I have something new to report, I will. And that's it. Leave it at that. If they keep bothering you, definitely if they let you go, you get on the phone, you call me immediately. Okay, employmentlawyer.ca for my contact information. Don't wait on that. Okay, very important. It will be illegal for them to do anything for you or to you. All right, with that last question from Carrie, I think that's the time that we have for today. Thank you guys always for joining me on this session. Real pleasure for me. Great questions today. I'm happy we had the opportunity to do that. I'll be back next week, same time, but don't wait until then, okay? If you want to connect with me, you can do that now, today. Email, phone number, just go to employmentlawyer.ca. Thank you, everyone. All the best to you. I'll talk to you again soon. Bye-bye.